Hello students, I'm Fiza Darakshan and I'm from Department of Political Science, Patna Women's College, Autonomous. Today we are going to deal with the topic Emergency Provisions in the Indian Constitution. To make the learning simpler, we'll split the topic into four parts. First, we will briefly understand the constitutional status of emergency provision in India. Second, we will try to understand the meaning of the concept of emergency. Next, we will go through the various types of emergency provisions in India, wherein we will also learn the causes, procedures followed by, and the effects of each kind of emergency. Fourthly and lastly, we will critically analyze the provision of emergency in India. We will first begin with the constitutional status of emergency. The emergency provision is dealt with in Part 18 of the Indian Constitution and are provided from Article 352 to 360, which makes a total of 9 articles. Indian Constitution is an amalgamation of provisions borrowed from the constitution of different countries of the world. Accordingly, the provision of emergency is borrowed from the Weimar Constitution of Germany. The founding fathers of the Indian Constitution incorporated the provision of emergency with the rationale to safeguard the sovereignty, unity, integrity and security of India, the democratic political system and the constitution. Moving forward, we come to the second part of our lecture, where we will exemplify the meaning of the concept of emergency. The Black Laws Dictionary states that emergency is a situation which requires quick action and immediate notice. As such, a situation causes a threat to the life and property in the nation. It is a failure of the social system to deliver reasonable conditions of life. Accordingly, we can explain emergency as a situation which arises due to failure of the government machinery, which causes or demands immediate action from the authority. The framers of the Constitution structured the government on a quasi-federal setup, which divides power between the centre and the state. This division of power in a federal or quasi-federal structure sometimes weaken the government. Thus, under extraordinary circumstance, power is conferred to union government. Coming to the third part of the topic, we will learn about the three types of extraordinary situation in which emergency can be proclaimed in India, the process of proclamation and revocation, and the effects of all the three types of emergencies in India. Emergency can be divided into three types as stated in Part 18. Article 352 deals with national emergency. Article 356 discusses President's rule, which is basically the state emergency. Article 360 talks about financial emergency, which can be proclaimed due to financial threat to nation's economy. Article 352 states that whenever there is a threat to the security of India or any part of the territory due to war, external aggression or armed rebellion, a national emergency can be imposed by the President in the entire nation or a part of it. There are three important amendments related to it. First is 38th Constitutional Amendment of 1975, which specified that different proclamations can be issued on different grounds, even if one proclamation is in operation. For example, if an emergency is proclaimed on the ground of war, another emergency can be simultaneously imposed on the ground of armed rebellion. Second is 42nd Constitutional Amendment of 1976 that made it clear that emergency can be imposed in the whole of country or a part of it. Third is 44th Constitutional Amendment of 1978, which replaced the term internal disturbance with armed rebellion in the Constitution. National emergency has been imposed thrice in India, once in 1962 during Chinese aggression, which continued during Pakistan's aggression in 1965, second during 1971 due to Pakistan's aggression, and lastly during 1975 due to internal disturbance, the term which was in existence then. Now we see the process of proclamation of national emergency. A national emergency can be proclaimed by the President of India only after a written confirmation given by the Cabinet and not only by the Prime Minister. The part that the President requires written confirmation from the Cabinet and not only the Prime Minister was added by the 44th Constitutional Amendment of 1978. Such a proclamation requires approval by each House of the Parliament within 1 month from the date of issue with special majority in each House. That is, majority of total membership of the House added by the 44th Constitutional Amendment and majority of not less than two-thirds of the members present and voting. What we need to note here is, if such a proclamation is issued while Lok Sabha is dissolved or it dissolves during 1 month of proclaimed emergency, the bill survives until 30 days from the first sitting of reconstituted Lok Sabha, provided it is approved by Rajya Sabha in the meantime. If it is approved by both the houses, the emergency continues for 6 months and can be extended to indefinite period with the approval from the Parliament for every 6 months, added by the 44th Constitutional Amendment again. Another point to note here is, if Lok Sabha is dissolved during those 6 months without further approving the continuance of such a bill, the proclamation survives until 30 days from the first sitting of reconstituted Lok Sabha, provided it is approved for continuance by Rajya Sabha in the meantime. President revokes the proclamation after receiving a written confirmation from 1/10 of total members of Lok Sabha to Speaker or to President if House is not in session, after which a special sitting of Lok Sabha is conducted within 14 days to consider the disapproval of the continuance of a proclamation. The revocation is passed by only simple majority. Next, we will see the effects of national emergency on centre-state relations, term of Lok Sabha and State Assembly, and fundamental rights one by one. The centre-state relation is affected by national emergency in three spheres. In the legislative and executive sphere, Parliament is empowered to make laws on any subject in the state list, or President can issue ordinance if Parliament is not in session. Such a law or ordinance, however, becomes inoperative 6 months after emergency has ceased to operate. The State Assembly is not suspended, though Parliament can override them. In the financial domain, President, with the consent of Parliament, can modify the revenue distribution between the centre and the state, which continues till the end of financial year in which emergency ceases to operate. The term of Lok Sabha and State Assembly under normal circumstances is 5 years, which can be further extended to 1 year at a time during national emergency. The extended Lok Sabha or Assembly, however, cannot continue beyond a period of 6 months after the emergency ceases to operate. We can take the example of the 5th Lok Sabha term, which was extended twice, so total term was served from 1971 to 1978. The effects of emergency on fundamental rights of people can be read under two articles. First is Article 358, which becomes operational only when emergency is imposed due to war or external aggression and not due to armed rebellion. Article 19 is automatically suspended and revived after revocation. The state can make any laws that are inconsistent with Article 19, which ceases to exist when emergency ends, but the effect of the laws made that are inconsistent with Article 19 cannot be challenged. Second is Article 359, which specifies that fundamental rights exist during emergency but cannot be enforced in the court of law, and only those rights shall be suspended which are specifically mentioned in the presidential order, and the state can make any laws that are inconsistent with such rights. However, Article 20 and 21 cannot be suspended. With this, we come to the end of national emergency. Moving on, President's Rule, which comprises Article 355, 356 and 365, is the provision given in the Constitution if and when there is constitutional breakdown in any state in India and the President is convinced by the reports submitted to him or her by the Governor of concerned state, which is embedded in Article 356, or if the state fails to comply with or give effect to any direction from the center. In such a situation, center takes control of that state, which is why the name President's Rule. The 44th Constitutional Amendment of 1978 also added the clause that Election Commission must certify that elections in the state could not be held due to difficulties. President's Rule is proclaimed by the President after it is approved by both the Houses of Parliament within 2 months by a simple majority, that is, majority of the House present and voting. If emergency is issued while Lok Sabha is dissolved or it dissolves during those 2 months, it survives until 30 days from the first sitting of reconstituted Lok Sabha, provided it is approved by Rajya Sabha in the meantime. If such a bill is approved in the Parliament, the President's Rule continues for 6 months and it can be extended for 3 years at most, with subsequent approval by Parliament every 6 months through simple majority only. A President's Rule can be revoked at any time by a proclamation by the President without parliamentary approval. As an effect of such state emergency, Chief Minister and Council of Ministers of the concerned state are dismissed by President, who then administers the state through the Governor with the help of Chief Secretary or advisors appointed by him or her. The State Assembly stands dissolved and laws and budget for the state are made in the Parliament or ordinances issued by the President if Parliament is not in session. However, the position and powers of High Court of the particular state remain same even during President's Rule. President's Rule has been often misused by the centre to establish its supremacy. For example, in 1977, the Janata Party imposed President's Rule in 9 states that were under Congress rule, and consequently in 1980, Congress at centre imposed President's Rule in 9 states that were under Janata Party rule. The 44th Constitutional Amendment also made President's Rule subject to judicial review, reversing the 38th Amendment of 1975, which made state emergency immune from being challenged. The Sarkaria Commission of 1988 and the landmark case of S.R. Bommai versus Union of India 1994 also attempted to explain the proper and improper usage of Article 356 to prevent the tyranny of centre. With this, we come to the end of President's Rule. Next, we have financial emergency that can be imposed under Article 360 if and when there is financial threat to nation, whereby centre takes full financial control of the states. India has not witnessed any financial emergency so far. However, we underwent financial crisis in 1991, which was resolved through the policies of the then government. A financial emergency can be proclaimed by President with the approval of both houses of Parliament with simple majority and within 2 months. If emergency is issued while Lok Sabha is dissolved or it dissolves during those 2 months of proclaimed emergency, it survives until 30 days from the first sitting of Lok Sabha after its reconstitution, provided it is approved by Rajya Sabha in the meantime. The Constitution does not prescribe any time limit for a financial emergency and it does not require repeated parliamentary approval to continue. The President, however, can revoke such a proclamation without parliamentary approval. Now we come to the last part of today's session, which deals with an assessment of the emergency provision in India. Emergency provision is criticized for destroying the federal character of the Constitution as it empowers union government over state, which could possibly lead to President becoming a dictator. Emergency also threatens states of their financial autonomy. It also imperils the observance of fundamental rights in the country, which destroys the democratic character of India. Thank you. I hope this lecture was fruitful for you.